It's dangerous to give an attorney a mic and also expect me to use a remote at the same time. It's going to be interesting, especially because I'm right-handed. So is this going to work? There you go. So I'll try not to read my presentation, but it is here in front of me. If you can't hear me or something, wave. So tonight I was asked to talk a little bit about advanced planning, and I'm not going to go into a lot of details about wills and trusts necessarily, because that's really designed for after people pass away. What I'm really here to talk about is planning for incapacity. And I know I'm kind of speaking to the choir because you all work with people or are associated with people who have capacity issues or may have capacity issues. But that's kind of the focus I have. And before I get started, in your bags, there should be a little thing that says estate planning is for everyone. I did not put my name. I was trying to be neutral and not very marketing and all that kind of stuff. But if you want my business card, I have them on the table. And also, I have a list of all the estate planning attorneys in the county. I don't have gazillions of them, but I have some, so if you want one, come by and I'll be happy to share that with you. And I also have a little like note card that has some, this is not in your bags, but I have some at the table that have some websites that have more information about these topics. Okay? So generally speaking, oh, I have noise. I didn't even know I had noise on it. Nobody likes to plan ahead for things like being sick or incapacitated, about injury or death. But we all know someone in our life who has had some sort of debilitating dementia, or they may have had an accident. They may be a vet who is suffering from PTSD. Different kinds of things that make that person unable to manage their own affairs. But we always think, well, there's always tomorrow, right? Winston Churchill told us many things, one of which was the person who fails to plan is planning to fail. And by planning ahead, you take some guesswork out. Obviously, we can't know everything that's going to happen in our lives, but if you do some planning ahead, some of the things like financial affairs that need to be managed, medical decisions and that sort of thing can be dealt with when you're not able to do it yourself. So I'm going to start with advanced healthcare directives. These are really pretty common, and all of you that work at the hospitals or medical facilities, you're probably trying to get every client that comes in to sign these. I know that they're readily available. You don't have to go to an attorney. The legislature has written a standard form, and most of these are able to get them at the hospital. You know, or I don't know if doctors have them so much, but a lot of hospitals do. This allows somebody to make medical decisions for you when you can't do it. Now, we're not talking end-of-life decisions. We're talking about healthcare decisions. This is you fall down and you break your arm and you're unconscious, and somebody's got to tell the doctor to go ahead and, set it. It's while you're in the middle of surgery and they find something they need to deal with. They have to have somebody who can tell them what to do. So it's not just end-of-life planning. Of course, end-of-life, Terry Schiavo type, situations do come up. It is something that you anticipate with these forms. Now, one thing it is not, and I want to point this out because somebody just asked me about it the other day, this is not a do not resuscitate order. If you want a do not resuscitate order so that if the paramedics arrive at your home and you don't want them to save you if you're, not breathing, your heart's not beating, you need to have talked to your physician about that and gotten that form, and it needs to be smack dab on your refrigerator so the EMT will pick it up. It's totally different from this. If they see a healthcare directive, they're still going to treat you. They're still going to revive you. They're still going to put you in the helicopter. You're still going to end up at the hospital. And then the doctor's going to look at your healthcare directive, if they've got it. Okay. As I said, you can get these forms. I put a reference in here on the web Coalition for Compassionate Care of California has a website. It's coalitionccc.org, and you can get a form right off there that's pretty standard. It's really important you follow the rules. When it says you need to have 2 witnesses that aren't related to you, that means you have to have 2 witnesses that are not related to you. If it says or get a notarization, then you need to get a notarization so you can choose. If somebody's in skilled nursing, then the ombudsman has to be involved. So you have to follow the instructions that are on those forms. If any of you have had a family member or someone who has lost capacity or is losing capacity, it's probably too late to get one of these forms. Now, the capacity standard for estate planning is lower than it is for contracts, okay? So somebody who's losing capacity they can get out of a contract they signed to buy a TV or buy a car, but they might still be able to do a healthcare directive. But it's a moving scale, and it's very difficult for even attorneys or doctors sometimes to figure out whether somebody really can make a decision like that. So do it now, do it early. Don't wait until it's too late to do that. The other thing a healthcare directive does, the funeral homes look at this, and then that gives them instruction as to who they can take instructions about disposition of remains. And I wasn't really aware of that. I knew you had instructions in there until a friend of mine who runs a funeral home told me that that's really an important document for them. So it's an important thing, okay? The other, I guess I should change pages here. So another one is a durable power of attorney for asset or financial management. I don't recommend this for all of my clients, okay? You really have to have somebody you trust to give a power of attorney. All of us have heard horror stories about somebody signed a power of attorney for their kid and they robbed them blind and left the country, and there they are. You need to be careful about these. A lot of couples do these so that their spouse can sign papers for them. And of course they do have one that's called a springing power of attorney, and what that means is it doesn't become effective until a doctor has declared you to be incapacitated. If you recover capacity, say you have a stroke or something and you get better, then you can take the power back again. But you'd have to have a doctor say you were capacitated again. Powers of attorney and healthcare directives end when the person dies. So, you know, I have people call, well, I had a power of attorney and my mom died. It's like, well, it's not any good anymore. Okay. Powers of attorney are very broad, or they can be very broad. They can also be very, you know, focused on a particular thing, but it allows the agent to manage property. What I find it really useful for is they can direct, for example, withdrawals from IRA or 401k retirement funds. This is really important. If one of the cases I worked with, the woman, the spouse was the beneficiary, but she didn't have a California power of attorney, and the bank would not recognize her Washington State power of attorney, even though it said she could manage retirement funds. She needed to increase, because he went into a care facility, she needed to increase the amount of his monthly withdrawal from his IRA. And it took an act of God to finally get that to happen. The person who's your agent can also apply for government benefits. So if I'm not eligible for Social Security right now, but if I were to have a stroke or something and needed to have Social Security disability applied for, my sister, who is my power of attorney, could do that for me. So it gives them the ability, they can apply for VA benefits or other benefits. Okay, again, this is something you want to be careful about, who you put this in. You don't just give it to anyone. The last thing I'm going to talk about is a revocable living trust. This is not a living will. This is not saying what you want to have happen, you know, if you have some fatal illness. Okay, a trust is like, my analogy is a camper truck, and you're going to go camping. And you load your property into that truck, and you're the driver of the truck, okay? But when you can't drive anymore, then whoever you've named as your successor can then drive the truck. And even if you're still alive, they can drive the truck, and they can manage your affairs, and you're still the beneficiary of the trust. When you pass, then that same driver is driving, and they can unload the truck based on the instructions you've given to your beneficiaries. So if you don't do it, what happens? If you don't have these kinds of powers in place, then somebody else is going to have to go to court. They're going to have to petition to become your conservator, either of the person, and if you have any sort of assets of your estate. That's an expensive process. It's very invasive. The court has to approve everything that happens. I am the attorney appointed by the courts here to represent conservatees in the county who do not have anyone to speak for them or take their part. And I have about 80 clients right now. These are mostly people whose family members can't serve as their conservators, so the county has stepped in. Conservatorships will eat up assets if somebody has them. So it's really better to do the planning, and plus then the court's deciding you're not. What's going to happen? So what can you do? Name a healthcare agent. Consider creating a power of attorney to manage your assets when you're not able to do so. But again, this is one, be careful. You should make a will, just because then people know what you want to have happen to your stuff when you're gone, okay? Consider a trust. The laws in California recently changed. The new probate limit is, instead of $100,000, it's now $150,000. But probate's okay, but it's also a nice moneymaker for us attorneys. And you can do all this kind of planning ahead and save your estate a lot of money. Now, you may pay, $1,500 to $2,000 for a complete estate plan with a trust. But if you have a $100,000 estate, the attorney fee is $4,000 by law for the attorney. That's the courts have said that's okay, that's it. So, you're already talking, and that's below the level for probate. Put all your important papers in one place. It may not be in total order, but have one drawer where they're all in. Make sure everything's in one place. If you do any of this estate planning, make a copy of it and give it to somebody else. Your agent, preferably. If you have a healthcare directive, make sure your doctor has a copy of it. Make sure that the hospital, if you're involved with Kaiser or something, make sure that they have it, okay? Look at your stuff. I just moved from a 2,800 square foot house to a 1,500 square foot house. I had a lot of crap, pardon my French, that I have collected over the last 32 years. And when I moved to Lake County, I got rid of a lot of crap then. And I'm like, where did it all come from? And so look at it. There's a lot of stuff. Do you really need it? My mom was sick for about 3 years before she died, and that was one thing, thank God she did, was she went through everything. She organized it. She had time, luckily, to do that. Think about your funeral arrangements. Now, I'm not saying run down and buy something prepaid. But what I'm saying is, thinking about it, write it down if you have particular instructions. Now, you may not want to do what my dad did. My dad was a civil engineer. My dad told us how deep the hole was to be for his cremains. He told us what the diameter was and how we were to open the decorative urn and pour the ashes in and mix it with dirt in a certain level and water. And my brother-in-law, being a contractor, followed his instructions. Now you have to understand, he was buried in Texas, and the dirt is similar to the cement we're standing on. And so I had to pay an extra $50 to the cemetery to dig it, just the way he wanted it. But communicate. Dad had written it down. My dad wrote everything down. And we knew what he wanted and how he wanted it done. He talked to us about it, and that's a hard thing. That's the hardest thing for my clients. They'll come to me, they'll do their estate plan, and I said, you need to sit down with your kids and talk about this. And they're like, well, my kids don't. I said, your kids need to know what your plan is, especially if they're cutting somebody out, okay? And amazingly, how many times that happens, sadly. Now, do you need an attorney? Well, Well, of course, attorneys think you need an attorney, but there's a lot of things you can do for yourself. There's a lot of ways you can save yourself money if you go to an attorney. Make sure you have a plan. Know what you want to do. Don't sit and talk to the attorney and pay him $200 an hour to figure out what you want. Figure out what you want before you go, okay? A lot of attorneys, I certainly do, and I know other attorneys do, will give you like a checklist asking you questions. But, you know, attorneys aren't perfect, but they do have a lot of practice, and they do practice a lot, so. And there I am. Lucky you. So anyway, that's my only advertisement, but if you have any questions, I'll be around afterwards.